Hello everyone and welcome to the first seminar of Schedule School. My name is Lois Norris. I am joined by Demi Newlove today, who is hosting with me, and Dan Herman. Just to explain a little bit about Schedule School for those of you who haven't seen it thus far, it is a free resource. It is hosted by junior practitioners like myself and Demi, and we are guided by senior practitioners, today Dan Herman. The purpose is effectively to take junior practitioners through schedules one step at a time, and we'll be covering various heads of loss from care and case management to loss of earnings. All of our webinars will be uploaded onto the website, so you can work your way through them at whichever pace you should choose. On the website, there are accompanying handouts and there will be slides available. Is that this is designed to be a resource of going back to basics as such. So whilst we will cover all of the generals, it should be said that there's always exceptions to the rule, and this is only designed to be guidance. It won't fit in every single case. I will hand over to my co-host Demi now, and we'll get started.
So as you may have noticed from the website www.scheduleschool.co.uk or the handout to this webinar, Webinar 1 Back to Basics, over these various webinars we will be developing a schedule of loss for our fictional claimant Penny Foster. The relevant facts of Penny's claim, which we will refer to throughout our seminars, are detailed on the mentioned resources. However, to briefly recap, Penny was involved in a road traffic accident, following which she was rendered paraplegic. Her accommodation is unsuitable, so she's currently renting an accessible bungalow, and she will receive significant care, rehabilitation, medical treatment, aids, equipment, and accommodation going forward. Our first speaker who will be taking us back to basics is Dan Herman. Dan is a partner in the personal injury department at Stewart's and head of the Leeds office. He is a fellow of the Association of Personal Injury Lawyers and also an accredited specialist spinal cord injury solicitor. Since 1999, he has only acted for clients with very serious injuries and has been involved in many cases where the claimant has received compensation of £1 million or more. Dan, Lois and I have seen your agenda for this session, but could you talk us briefly through the common purposes that a schedule of loss is required?
Sure. There are various reasons why you might put together a schedule of loss. Obviously, if you're issuing proceedings, you're going to need a schedule to accompany the particulars of claim. In those circumstances, your schedule is probably going to be limited to some information about general damages and details in relation to past loss. You're probably not going to want to go into the future losses too much, because otherwise you'd risk unilaterally disclosing your expert evidence or revealing what it says. If you made an interim payment application, you'd want to convince the court the likely value of the claim, or at least the likely value of certain elements of the claim following Eales and Cobham. So again, you'd want to have past loss in there, you'd want to set out your accommodation claim, and you might want to set out other heads of loss projected 12 or 18 months forward until the likely date of trial. You might want to put together a schedule just for your own purposes. If you get an offer in on a case, Part 36 or otherwise, you might need to quickly value the case to be able to advise the client on the merits or otherwise of that offer. If you're engaged in ADR, whether it be a JSM, mediation, or some other form, you'll need to put together a schedule. In those circumstances, your schedule might be sort of a hybrid schedule come skeleton argument. You might be wanting to make various points in that without prejudice schedule to try and persuade the defendant of your position. And of course, you may well require, or you would require, a schedule for trial. That isn't going to be full of submissions and legal arguments. It's going to be restricted to the facts and the evidence, but that's the single most important document at trial. It's likely going to be the document that counsel directs the judge to read first of all in the reading list. And so it's a real opportunity for a claimant to set his or her stall out and impress upon the judge the nature of the case, the nature of the injuries that claimant has sustained, and the losses that are likely going to flow from it.
Okay, thank you for that, Dan. So there are obviously two overarching points here. We're going to be painting two pictures. So we're looking at what would have happened if the accident hadn't occurred and what is going to happen now. Before starting to draft the schedule, it's really important to be in a good position of reviewed all of the evidence. And from a paralegal point of view, I think it's really important to keep on top of incoming receipts, keeping an up-to-date cash reconciliation statement with rolling copies of the invoices and receipts. That means that drafting the schedule of loss isn't something that happens at a point of just before a JSM or at a point of just before trial. It's something that a paralegal can be working on from the beginning of the case, making sure that everything's prepared and available for when it's needed. It will make everything a lot easier when it comes down to it. Dan, would you be happy to take us through the math from here?
Yeah, well, in terms of preparing for the schedule of loss, I mean, there are some points which might seem blindingly obvious, but you really do need to read all the quantum witness statements and all the expert reports. And as you're going through those witness statements and those expert reports, you're looking for certain milestones in the case. You're looking at what point, for example, the claimant might move home, or the claimant might want to start a family, how many children the claimant's going to look to have. You might want to look at where the claimant may have been promoted had they not been injured, or what would happen with their career when they would have moved house in the uninjured scenario. And equally, in the injured scenario, you need to be looking at what your experts are saying about what the future holds for the claimant. So that might be when they require certain types of equipment, or when their care regime is likely to increase in size and cost. So as you're reading through the witness statements and expert reports, constantly jotting down when these milestones are in the claimant's life, both in the uninjured scenario and in the injured scenario. You've also got to make sure you've got the right tools for the job. You don't actually need many things. You need this book, Facts and Figures, which always used to be red or yellow. It would change between the two. This year, for some reason, they've decided to do it in silvery grey. If you're anything like me, you need a pen and paper because you will be jotting lots of things down. Obviously, you need a calculator. And another resource that I definitely recommend, which I don't have on me because it's in the office, is a book called Personal Injury Schedules Calculating Damages, which is currently in its 4th edition. Its general editor is William Matamsea, QC, and one of my partners, Julian Chamberlain, also contributes to that. But it's a really excellent resource.
That's really helpful. And also for anyone watching this, you might want to have a pen and paper, because the idea is going to be that we will go through some of the calculations as we go along. Going on to the maths, I'm going to let Dan take that, and I've got written down here, make a joke about how long Dan Herman's been doing schedules. Well, I saved you from that, Dan. How many years has it been, Dan, that you've been doing schedules, just to assist us?
Just so you can take the mickey. 25 years.
Oh, good. Okay, perfect. And that's why we are being guided through it today by Dan, because he has been doing them for such a long time. But one of the first things that you want to do when you're doing schedules is write down the key dates. And Dan's touched upon that just then. So if the accident had not have happened, and because of the accident, those key dates. So date of birth is obvious, date of accident, the date of service of proceedings, that's helpful for calculating interest on general damages. Well, not only helpful, it's essential. And the date of calculation. Now, for the purposes of Penny Foster, our fictional case study, that date is taken as the date of the joint settlement meeting, which is scheduled for the 1st of September 2021. But those dates can differ, and it could be the date of trial, or as Dan said, if you're just calculating it for evaluation, you may pick a random date as such. You also need to know the age at date of the accident. In relation to the exact date, age at the date of the accident, we can see here Penny is 35.82 years. I don't think it's any secret that there's various websites that can calculate the exact age for you. The age at the date of calculation is 38.28 years. We're going to be looking at various phases throughout, and there's also life expectancy. This list is not exhaustive. Obviously, if we were looking at loss of earnings, there would be the date of retirement, but we're going to be coming on to that in later seminars, and today's just a brief introduction.
So life expectancy is very important when drafting a schedule of loss. One of the largest parts of the schedule of loss is going to be Penny's future losses, which are calculated from the date of the calculation to the end of her life, in this case being 75. Penny's significant needs for care, rehabilitation, medical treatment, aids, equipment and accommodation are going to form the vast majority of the claim. Penny's life expectancy will have been calculated by an expert in their report. So Dan, could you take us through which different approaches experts can take when discussing life expectancy?
Sure. First thing to say is this is a fairly simplistic outline of what experts might do. We could deal with life expectancy as a standalone topic for 45 minutes, but in the nutshell, obviously a claimant can have normal life expectancy, in which case you would simply be using, as we'll come on to see, tables 1 and 2 when dealing with lifelong losses. But generally speaking, in catastrophic injury cases involving brain injury, spinal cord injury, other forms of life-changing injuries, the claimant will have an atypical or an impaired life expectancy. And experts can either produce what I might call a generic assessment of life expectancy, might say, for example, someone with T4 paraplegia will lose X% of their remaining years. Not do it bespoke, specific to that particular claimant, but just offer a generic view. Alternatively, and preferably, your lead expert in your case, in this case it'd be a spinal cord injury consultant, would put together a bespoke assessment of the claimant's life expectancy. So the expert will be looking at the positive, neutral and negative factors, both in relation to the claimant's general health, including their pre-injury health, and any issues relating to the injury they've sustained as well. So for example, if Penny had been a lifelong smoker, that would be a negative factor. If, however, Penny had never smoked, that would be a positive factor, because included in the general population are people who have smoked. Similarly, in relation to her injury, if Penny had largely avoided urinary tract infections, pressure sores, other complications that can arise in case of spinal cord injury, that would be a positive factor. Alternatively, if she'd had many UTIs and lots of difficulties with her skin, that would be a negative factor. And so the claimant's expert will need to look at all these various factors and then put together a bespoke assessment of her life expectancy. Typically, generic assessments, you can usually see whether it's a generic assessment because the expert will talk about life expectancy being reduced by a certain number of years or life expectancy being reduced by a certain percentage. And generally speaking, bespoke life expectancies will talk about the claimant living to a specific age or living a further number of years. It's not as simple as that, though. You can't always take that as your rule of thumb. But it's important to understand what type of life expectancy assessment your expert has made, because that will then inform how you go about looking at further lifelong losses, including working out your life multiplier.
Okay. So moving on to multipliers and multiplicands. Dan, firstly, can you sum both of those up very briefly?
Sure. The example I usually give to clients is, let's assume that they have an annual loss of £1,000 for physiotherapy and they're going to live a further 40 years. They would expect to receive £40,000, 40 years times £1,000 per year. And they're sometimes surprised when I tell them that's not the way of dealing with it. In actual fact, in the scenario I've just given you, 40 would be the multiplier and £1,000 would be the multiplicand. So the multiplicand is the annual loss and the multiplier is whatever you multiply that by. However, unless the discount rate is 0%, and it's not far off 0% at the moment, you'd have to actually work out what the appropriate multiplier is going to be. And the way you do that is to, first of all, understand what the discount rate is. There's been lots of talk about the discount rate recently. It's currently minus 0.25%. What is the discount rate? Well, the discount rate is the assumed rate of return on the claimant's low-risk investments, taking into account inflation, tax, and expenses such as the cost of investment advice, the cost of changing funds, etc. From time to time, the Lord Chancellor sets that. It's most recently been set at minus 0.25%. So that's the rate we work with.
And so we have just been speaking about the importance of life expectancy and the two different approaches, effectively generic or bespoke, that experts can take. Dan, how does the approach the expert take dictate how you use the Ogden tables?
Let's assume that the expert has taken what I've called a generic approach. So simply said, someone with a spinal cord injury such as Penny would expect to see a reduction in life expectancy of X% and hasn't made it specific to her and her particular circumstances. In that scenario, you would use table 2. So tables 1 and 2 are for lifelong losses, table 1 for males, table 2 for females. So let's, for the purposes of this simple example, assume that Penny is age 38 at the date of calculation. She won't be, she'll be 38.28, but we'll come on to that in a second. Let's also assume that her normal life expectancy is to age 88, but expert medical opinion says reduced by 13 years to age 75. What you would do in this scenario then is to artificially increase her age by 13 years, so add 13 to 38 to arrive at 51. You then turn to table 2 in the Ogden tables. You would look at the minus 0.25% column. You'd run your finger down that until you got to age 51, and you'd see there that the appropriate multiplier for lifelong losses was 37.96. That's how you'd arrive at your life multiplier with a generic assessment of life expectancy.
And then we also have table 36. Can you explain how that ties in with the bespoke life expectancy assessment, as we're calling it, and how you would calculate that? And it's probably worth saying at this point, some of the tables we refer to today are available on the Ogden table, so you can get them online. Table A5, which we'll come on to, isn't. It's available in facts and figures, so it's helpful to have those in front of you if you do. But for now, looking at table 36, which is available online, Dan, talk us through the bespoke calculation.
Sure. So table 36 is headed multipliers for pecuniary loss for term certain. It's table 36 in the 8th edition of the Ogden tables. You might see it referred to as table 28 because in previous editions it was table 28, but they've introduced some further tables, they've inserted them in between, so it's bumped it up to 36. So if you hear table 28, it's the same thing in previous editions. So this is not a table which is dealing with the lifelong losses of a male or a female. It's simply an actuarial table looking at losses for a term certain, for a specified period of time. So if your expert has put together a bespoke life expectancy, then the case law currently suggests that the more appropriate approach would be to look at table 36 when working out your life multiplier, rather than looking at table 1 or 2. Because if you look at table 1 or 2, you'll be double discounting. You've already discounted for mortality in your expert opinion, and you'd be discounting again further by looking at tables 1 and 2. Table 36 doesn't allow any risk of mortality. It's simply looking at what the actuarial numbers are for that particular period of time. So again, if we assume that the claimant will live to age 75 from the age of 38, that's a further 37 years. So again, table 36, minus 0.25%, run your finger down there until you get to 37 years, and you see the multiplier is 38.77. And you know there's quite a significant difference between the two multipliers. The multiplier, if you're using table 36, is, I think, 0.81 higher than the multiplier using table 2. And that's very significant because the losses that a claimant in a catastrophic injury case might be incurring in the later years of life could be in the hundreds of thousands of pounds. And so even a difference of 0.81 on the life multiplier can actually result in a very different outcome in terms of award.
That's helpful. So in effect, if you've got what we're calling the generic life expectancy assessment by the expert, you're looking at tables 1 and 2. If you've got the bespoke life expectancy assessment, then we're looking at table 36.
Yeah, that's very much a rule of thumb. It won't suit every single case, but as I say, we haven't got the time to go into all the law on life expectancy and the appropriate multipliers.
So this for me is one of my favourite sections of the PowerPoint, purely because through our draft run through, we have disagreed about how this is pronounced. So me and Lewis believe that this is pronounced interpolating. Dan, can you remind me how you pronounce it?
Well, the correct way of pronouncing it is interpolating.
That's a very senior Silk who agrees with us, which would mean that Dan has potentially been pronouncing this wrong for 20 plus years. He argues that the dictionary pronounces it the way Dan does, but I don't think Syrian technology pronounced things correctly, but we'll leave that there. You want to take us through that, Dan?
Sure. So the examples we gave then, we used Penny's age at 38. in reality, it'll be very rare. I can't think of any cases where the claimant will be exactly a whole number of years old at the date of calculation, or alternatively will have exactly a whole number of years to live from the date of calculation. What we need to do is to interpolate the multipliers. And what that means is to work out what the appropriate multiplier is in between 2 years. So let me give you an example. We know that Penny is going to live for a further 36.72 years. That's 75 less 38.28. So we need to interpolate between 36 and 37 to find the appropriate multiplier. Now, the formula I've always used, and it's the same formula that's suggested in the explanatory notes to the Ogden tables, is the one on screen now. There are other formulas that you can use, and they will arrive at exactly the same result. They're perfectly sound mathematically. It's just that this is the one I learned, so I'm explaining this one. So there's only 3 inputs into this formula. So x I've described there as being the multiplier for the integer below the claimant's age or term certain. So if we're looking for, if we're using table 36 and we're looking at a multiplier for 36.72, x is going to be 36. It's the whole multiplier below the term certain, and y is going to be the multiplier for 37. Z is the period of year elapsed since x. So with 36.72, the period of the year that's elapsed since x is 0.72. So to be clear, x is going to be the multiplier for 36, which is 37.67. Y is going to be the multiplier for 37, which is 38.77. And Z is going to be 0.72. And we can see on the next slide how that works. So as I say, you've got your multipliers there. So it's a very simple calculation, 37.67 minus everything in the brackets there, which turns out to be 37.67 minus 1.1 times 0.72, which is 37.67 minus 0.792. So effectively adding that. So it's 38.46. And if you look at the numbers for 36 and 37, that kind of looks about right. You know, it sits somewhere between the two, but more towards 37 than 36. And that's, joking aside, that's quite a good way of checking it. So that if the number isn't between those two, or doesn't look to be right, you've probably made a mistake somewhere in your formula. So that's how you interpolate, or however else you want to pronounce it, between 2 different multipliers. I should say that's how you interpolate table 36. That works for table 1 or table 2 as well. When you're dealing with table 2, in the case of a female, as Penny is, then x, the multiplier for x will be higher than the multiplier for y, so it will result in a positive number, but it's still the correct formula to use.
That's really helpful. So with the life multiplier, that works perfectly well if the loss will stay the same for the rest of the claimant's life. So using the example that you can see on screen now, if care is to be £100,000 every year for the rest of Penny's life, then it's fine to use the life multiplier. However, if the losses are to change, then you need to take a different approach. And this is when we come on to splitting multipliers. If the loss is going to change over the claimant's life, then a different approach will be required. And using our scenario of Penny Foster, we're going to adapt some facts in relation to her care. We're going to say that Penny's care will be £30,000 a year to age 40, £50,000 from age 40 to 50, £80,000 from age 50 to 60, and thereafter £100,000 from age 60 for the rest of her life. And that's the cost per annum. Dan, do you want to talk us through your table?
Yeah, again, this is the way I was taught to do it. I'm sure there are other, perhaps more efficient ways to do it, but this is what I do in practice. I don't get a nice fancy Excel table like that, but I just draw these lines in my notepad and with these headings along the top. So first of all, I set out my various ranges. So we know the range is to age 40, 40 to 50, 50 to 60, 60 for life, which is 60 to 75 in Penny's case. What I then do is just set out what the periods are and how many years from the date of calculation till the end of that period. So to age 40, we know it's a period of 1.72 years because she'll be 38.28 at the date of calculation. So the number of years from date of calculation to the end of that period is 1.72. Until she's from 40 to 50, it's a 10-year period, and it's going to be 11.72 years until she arrives at the age of 50, and so on and so forth. So you look at the years to the end of that period. The next thing to do is to, again, interpolate the multipliers for each period. So the first period is 1.72. So you're going to interpolate between the multiplier for 1 year, which is 1.00, and the multiplier for 2 years, which is 2.01. And when you do that calculation that we saw a few moments ago, you'll arrive at a multiplier of 1.73. Similarly, with the next period, 11.72, you're going to interpolate between the multiplier for 11 years, which is 11.15, and the multiplier for 12 years, which is 12.18. And again, that arrives at 11.89, and so on and so forth. So you work out the multipliers for each period. Now, the next thing that you would then do is to split that multiplier. So we know that the multiplier to age 40 is 1.73. We know the multiplier to age 50 is 11.89. So the multiplier for the period from 40 to 50 is simply 11.89 minus 1.73, which is 10.16. Again, the multiplier to age 60 is 22.32. If you take off the multiplier to age 50, 11.89, you get the multiplier for that period from 50 to 60. Or alternatively, if you take off the split multiplier for 40 to 50 and to age 40, you'll still arrive at 10.43. And you do that for each period that you have there. And a good way of just checking you got it right is to add up the split multipliers. And split multipliers should be the same as your life multiplier, 38.46. If it's not, you've done a miscalculation somewhere. So it's a good way of checking that. So once you have your split multipliers, you can then pencil in your annual losses for each period. And then, of course, by multiplying the annual loss by the split multiplier for each period, you arrive at the claim for care for that period. You tot it all up and you arrive at the total claim for care.
Thanks, that's done. So if you're trying it at home, you might want to go back through that and go to the tables and you'll be able to check that it's right, because it should add up to 38.46.
Thank you, Lois and Dan. So as we've just seen with care, the multiplicand does not need to be the same, but the loss needs to be ongoing and continuous. The scenario here, just to explain, if the client is not going to buy an item for 20 years' time, the vehicle costs £50,000, for example. If the claimant simply receives this £50,000 at the date of the settlement, then unless the discount rate is 0%, the claimant is going to be undercompensated if the discount rate is negative, or overcompensated if the discount rate is positive. So this used to be called discount for accelerated receipt, but now in the days of the negative discount rate, it is known as credit for accelerated receipt. In short, Penny would be undercompensated in this scenario. Everything we are saying about interpolation, should it be splitting and so forth, only matters if the discount rate is something other than 0%. 0% makes it very easy, and we are very close to 0% at minus 0.25%. But if it's not 0%, then it's less obvious. In practice then, Dan, using this vehicle as an example, how would you go about calculating the sum the claimant should receive now to reflect the fact that she is going to incur a loss of £50,000 in 20 years' time?
We move to a new table. So unfortunately, this table is not available free of charge on the government website, but as I say, it is in facts and figures. It's table A5, which is at page 39 of facts and figures. And if you happen to have that in front of you, it looks like this. You can see that. And what this does, if you look at the column furthest to the left, which is headed single payment, it tells you what the factor is to apply to the capital sum to acknowledge the fact that it's being received early. So in the scenario that Demi's just outlined, if the claimant's going to buy a vehicle costing £50,000 in 20 years' time, you need to look at table A5, run your finger down to year 20, and you see the factor there is 1.051. So if you multiply £50,000 by 1.051, you arrive at a figure of £52,550. And that is the appropriate sum to be claimed at the date of calculation for a capital sum of £50,000 to be incurred in 20 years' time. And what you'll find is over the whole schedule, there'll be lots of individual items which might not be required for some time. So, for example, the claimant might not need a particular piece of equipment until they are less able some years further down the line. And so you need to give credit for that accelerated receipt.
Thanks, Dan. And now dealing with replacement factors. Taking the example that is on screen, if we are to assume Penny needs a new wheelchair, which costs £3,000 every 3 years, then we need to look at replacement factors. And our giant wrong stamp that is displaying on the screen now is to explain what you shouldn't do in this scenario. So if we are to see that Penny needs a wheelchair every 3 years, costing £3,000, then at first blush, what you might want to do is say, well, that's £1,000 every year, and take the life multiplier of 38.46, and you get to a figure of £38,460. That isn't the way to calculate it properly. It's fair to say, I think, that is sometimes done in care reports, for example, or expert reports, because they might think £3,000 every 3 years, so we'll break it down. And certainly, it may be that if you're going through a report quickly, that might be a way to do it. But when you're calculating it manually, that isn't the proper way to work it out. And Dan, you're going to explain how you do work it out if you have that scenario.
Yeah, so in the scenario that we just talked about, it isn't an ongoing continuous loss spread over 3 years. It's a single expense of £3,000 at the end of year 3, and another single £3,000 being spent at the end of year 6, end of year 9, and end of year 12, and so on and so forth. So it's not a linear spend as it would be using a life multiplier. So again, we use table A5, the multipliers for fixed periods and at intervals. So what I do when I know my life expectancy, we know in this case that Penny is estimated to live for a further 36.72 years. So that's what I literally do. I get my ruler, I get table A5, I look where the year 36 is, because she's not going to make it, unfortunately, to year 37. I put my ruler under 36. I'm trying to show you, not the easiest thing to do. And I can see there all my various replacement factors. So my replacement factor, if something is renewed every 1 year, for example, a car insurance premium, is going to be 37.72. For 2 years, 18.88, 3 years, 12.60, 4 years, 9.47, and so on and so forth. So different items of equipment might need to be replaced at different replacement factors. A wheelchair might be 3 years, a car might be 5 years, a specialist bath might be 15 years. So you're looking at all your different pieces of equipment, and you're looking at the appropriate replacement factor. So if we use table A5, so what we're actually going to do now is to say, well, the replacement factor for 3 years for someone who lives a further 36.72 years is 12.6. Now, as I said before, that assumes a purchase at the end of year 3, year 6, year 9, and so forth. If the claimant also requires an immediate purchase, she needs her wheelchair for the first 3-year period before she buys her first replacement, you add 1 to that. So you'd arrive at 13.60. So 13.60 times the £3,000 capital cost is £40,800. And you will see that's quite a bit more than it would be if you simply applied the life multiplier. It may not be a huge amount for this one item, but if you think about all the numbers, all the items of equipment a claimant might be required over the course of their lifetime, the difference can really add up. And so it's important that you use the correct methodology.
Perfect. So calculators down, we have now done all of the maths. That might feel like we've gone through that fairly quickly. 2 things: you can take it at your own pace with our worksheets and going through the slide. And the second thing to say is that lots of these will come up again through the next webinars. For example, our next seminar will be care and case management. And obviously, some of what we've just learned is going to come in again. So now moving on finally to some more generic points. So the format of how you do your schedule, should you be doing it in Word, should you be doing it in Excel, or should you be using bespoke software? And I think it's fair to say that the opinion we all had is there's no, hard and fast rule as to how you should do it. Dan, would that be a fair assessment?
I think so. I mean, I always used to do my schedules in Word because I was pretty IT, pretty poor at IT. But I really wouldn't recommend you doing them in Word these days. I think really the choice is between doing them in Excel or using bespoke software. We know that there is bespoke software that's available now, and why wouldn't you use it in a sense if it's going to make it easier? I still think it's important though to understand the methodology and the math that underpins that software, because you can spot mistakes then either in your own schedule, or you can spot mistakes that your opponent might have made in their counter schedule. But I personally do my schedules in Excel. As long as you've got the formulas underpinned on a separate sheet, it means that if you do have to make a concession in relation to life expectancy, or you make a concession in relation to a particular head of loss or a multiplicand, you change it on your spreadsheet, it all filters through, and it does the job for you. But horses for courses.
Yeah, and I think the important thing is that if you understand the background to how you do these calculations manually, then it means that you can always do them and check them yourself. Dealing briefly with the order of schedule, again, when we were having a chat before this, there's some difference in the order that we would approach it in. Dan, do you want to take this, and then we'll comment on your controversial decision on it in terms of past and future?
Sure. Well, I mean, there's no hard and fast rule here, is the first thing to say. The most important thing is that the schedule is set out in a way that's going to make it easy to understand. It's going to make it easily digestible for the judge. Ultimately, that's your audience, isn't it? So what I would generally do is start with a summary, which would set out all the various heads of loss. So the award for general damages, usually PSLA, the various past losses, interest on past losses, future losses, and then give credit for any interim payments that have been received to date. I'd follow that with all the essential data that we've talked about. So that's going to be all the key dates, all the key facts. It's going to be all the various multipliers. It's going to be your replacement factors, etc. I then set out the background, but this is a real opportunity here for a claimant to speak directly to a judge. You can set out the story, effectively, of this claimant's life, what their hopes, aspirations, plans were pre-injury, and how that's changed given that they have now been injured, and what the future likely holds for them. Now, this is the controversial bit. With the individual heads of loss, whether that be earnings, care, accommodation, aids and equipment, etc., my preference, and I know I'm very much in the minority, my preference is to set out past and future losses back to back for each head of loss. I just think it's a very easy way to present it to a judge. You deal with a past loss of earnings, you go straight into future loss of earnings. Otherwise, a judge is looking at a past loss of earnings, and then 20 pages later, after reading about all the other heads of past loss, they get to future loss of earnings. It's a style thing. I do it that way. I still set it out grouped as past and future in the summary, but I think in terms of telling the story and the narrative, it's easier to deal with it that way. And in particular, in relation to accommodation claims, that doesn't lend itself neatly to splitting between past and future losses. Then you deal with interest and you deal with your appendices. I really would say that people should really make use of appendices. One of the worst things in the world is to see a schedule which includes every single invoice for cognitive behavioral therapy or physiotherapy or occupational therapy set out there. Often, dozens and dozens, if not hundreds of sessions of physiotherapy all set out in the main body of the schedule. You don't need to do that. The claimant has undergone X number of sessions of physiotherapy between X date and Y date. The total cost is Z. Further details to be found in the appendix, and then deal with all that later on. The judge doesn't want to read all that. I know you've got a different view, Lois, in terms of the order in which things should be set out.
Indeed, but as Dan says, there's no hard and fast rule. If you find it better to put past losses first and deal with future losses later, then that's fine. As Dan says, the important thing is that the summary contains both in a way that's accessible. Dealing briefly with the form of award, Dan.
Yeah, again, the schedule is about putting your best foot forward. If you've got a claimant who is absolutely adamant that they want periodical payments for certain heads of future loss, typically future care and case management, for example, why express that in your schedule as a capital sum? You should express it simply as a periodical payment. Make it absolutely clear, both to the defendant and the judge, that that is that's the claimant's wish. That's how the claimant intends to take her damages, and so that's the way to present it. Alternatively, if the claimant doesn't have a fixed view, you may want to set out both the capital sum calculation and how it would be set out as periodical payments as well. We skipped over content just before, and just a very quick point to make, which is this: in the same way that we're all taught not to plead the law in a particular claim, you really shouldn't be making sort of legal argument in the schedule. I'm very much of the view that the schedule should be restricted to the facts and the evidence. So of course you need to refer to the witness statements and refer to the expert evidence. You may want to quote certain sections of the expert evidence in the narrative of your schedule. You may want to put footnotes in to take the judge to particular pages within the trial bundle where an item might be found. But what you don't want to do is to start making legal arguments and submissions, maybe in a without prejudice schedule for a JSM, but certainly not for a trial schedule.
Perfect. So leading on to our final points today, as we say, hopefully we've just given you a brief introduction. But our final points, Dan, do you want to take these? Because these were your 3 bullet points in relation to the final points to leave with.
Yeah, I mean, schedules are about the math. They are about the numbers, but it's more than that. It's about the story. And if you can properly tell the story about this particular claimant, to explain to a judge why she needs a certain level of care, why she needs certain types of equipment, to explain to a judge how how her career would have progressed had it not been for the accident, and how that career progression has been affected by the accident, then that will help. I don't think that it should be an essay. I don't think you should be given over to lots of narrative, but the right amount of narrative, the right balance between narrative and figures is of crucial importance. As I've said, it should be evidence-based. Every single number, every single figure in your schedule should be supported by evidence, either lay evidence or expert evidence, or in the ideal world, both. That you shouldn't be making things up along the way and sticking numbers in that you think might be about right. And the final thing to say is that schedules should be internally consistent. This is one of my real bugbears with schedules that I see, and counter schedules as well. Too often you see people trying to maximize certain heads of loss without thinking about whether it is internally consistent. Say, for example, a claimant might say, I would have earned huge amounts of money had I not been injured, so as to make the loss of earnings claim as high as possible. But at the same time suggest that they would have lived in a very, very small property to make the accommodation claim now as high as it can be. The reality is the judge will probably think that someone earning a very high salary will probably, but not always, live in a pretty nice property. And so it's important to make sure that the schedule and the counter schedule, if you're acting for defendants, is internally consistent. But otherwise, you're just setting yourself up for a fall.
Perfect. Well, hopefully that has been useful to you all. This was our introduction back to basics. The next seminar will cover care and case management. So we will be using some of the things we've learned today, but also expanding upon that, particularly in regards to care and case management. Thank you to Daniel for being our speaker today. Thank you, Demi, for hosting with me. And hopefully we'll see you all at our next seminar. If you do want to submit any questions about what you've watched today, if there's anything in particular that has confused you, I'm on LinkedIn, and also myself and Demi are on Twitter. Please do get in touch with us by direct message, and we will try and incorporate it into the beginning of the next session. All right, thank you very much.
Thank you. Bye.